Okay, so we're going to look at the relationship between courts and Parliament in lawmaking. Really, Parliament and the courts need to work together. Parliament's main role is to make laws, and the courts are responsible for settling disputes, and they do have a small lawmaking role as well. Both need to work together. They need to interact to ensure that the law is flexible and that it can apply to any situation. So Parliament tends to make the laws, and then the courts apply them to cases that come before them. In essence, they're symbiotic. They need to work together, and they need each other to ensure that the law is flexible and that it works and that justice is provided. There's a number of relationships. Firstly, Parliament passes acts which actually create the courts. Then courts apply and interpret the law made by Parliament and subordinate authorities. Parliament can actually change law made by the courts, and courts can actually influence Parliament to change the law. We're going to look at each of these key relationships in a little bit more depth. Firstly, Parliaments establish the courts. For a court to exist, there needs to be an Act of Parliament that establishes the court and sets out its jurisdiction, the type of cases that it can hear. For example, the Supreme Court Act 1986 in Victoria established the Supreme Court and set out the types of cases that it was able to hear. Once established, courts actually apply and interpret laws made by Parliament. They apply statutes to the cases that come before them. Sometimes they might need to interpret statutes, as we've seen previously, and then those interpretations, or the reasons for the interpretations, create precedents that become part of the law. A good example of that was Franklin Dam case, where the High Court interpreted the meaning of external affairs in the Constitution. Parliament can change or confirm common law. They can pass an act to enshrine common law in legislation if they agree with the decision. They can actually override common law or abrogate it if they disagree with the court's decision. A good example is the rape within marriage case, where the Parliament abrogated the common law established in that case. And court decisions can influence Parliament to change the law. They can do that through their decisions, their precedents that they create, or obiter dictum in their case may influence Parliament to change the law. We've seen that through creativity by the courts can alert Parliament to the need to change the law. For instance, the Mabo case led to the Commonwealth government passing the Native Title Act. Sometimes court decisions can highlight problems with the law, and sometimes courts are too conservative and reluctant to change the law. We've seen in the Trigwell case, the obiter dictum there was very influential on the Victorian Parliament changing the law. So really that's it. 4 key elements of the relationship between Parliaments and the court. You need to make sure that you're able to explain all 4 of those and be able to apply them to any sort of case study that you might get